In a judgment that is likely to frustrate and perhaps confuse a great many people across the country, the Court of Appeal has ruled that, first of all, the Home Office can intervene in the case with the Bell Hotel in Epping, and secondly, rather more importantly, has set aside the interim injunction which would have required asylum seekers to be removed from the hotel by the 12th of September. The only logical reason I can get behind that is why move them out by the 12th of September if the substantive hearing in October may be unsuccessful and they might be allowed to stay anyway. I don't think that will be unsuccessful, but I'll talk about that a bit more later. And otherwise, I'm going to be quite candid in this video, so I mean this with great respect in this video, but I fundamentally disagree with the ruling of the Court of Appeal, and I'm going to give you my reasons why. And I agree, in fact, with what the High Court judge said, and again, it will become clear why. First of all, if you do like my legal input on these things, please do like this video. That helps to share it with a wider audience, and subscribe to the channel. That is absolutely free. I'm aiming for 1 million subscribers. This is truly a passion of mine, as it has been now for 5 years, near daily videos. So thank you so much for doing that. So I'm going to kick off this video with the sentiments that I think a lot of people will share, with a comment from Robert Jenrick on X here, and read out as follows. He says, "This is an extremely disappointing decision." He said, "Yvette Cooper's used taxpayers' money, your money, to keep open a hotel housing illegal migrants. The government's lawyers argued accommodating illegal migrants was in the national interest. In court, they said that the right of illegal migrants to free hotels is more important than the rights of British people. Well, they're not," he says. He says the British government should always put the interest of British people first. Starmer's government has shown itself to be on the side of illegal migrants who have broken into our country. Now, I'm just going to pause for thought there for a moment, because sometimes people say that coming to the UK to claim asylum is not an offence. Well, coming to the UK without permission, without leave, remains an offence. Of course, it's not an offence to claim asylum, but if you get here illegally to do so, the getting here illegally a bit remains an offence. Let's move on. I'll make it bigger so you can probably see it a little bit more clearly. He goes on, "But this is not a free pass for asylum hotels. Councils can and should still act to close those hotels. If they don't, residents will be rightly asked, on whose side are they?" He says, "My team, Law for Borders, will continue to provide legal assistance to help protect communities. There is no acceptable accommodation," he says, "for illegal migrants. The government should be prioritising Brits in need and deporting every illegal migrant, as the last government should have done, and I've argued for years." So let me just talk a little bit about what the court said and why I actually disagree with it. And I mean this with great respect, but I fundamentally disagree with what the Court of Appeal has ruled here. So I'm going to borrow a summary of what the court said from Daily Skeptic here. So I'll put this up on screen here. It says, "The three judges have ruled that Mr. Justice Eyre made a number of errors when granting the temporary injunction. Lord Justice Bean said, we conclude that the judge made a number of errors which undermine his decision." And then there's 3 points which sort of overlap, which I'm going to take sort of in turn and tell you why I disagree. It says the judge's approach ignores obvious consequences that the closure of one site means capacity needs to be identified elsewhere in the system. Now, the reason that I disagree with this is that this reasoning focuses on capacity to be identified elsewhere in the system by the Home Office, not by Epping. And it's not a planning matter consideration for Epping that they are found somewhere else to reside elsewhere in the system, elsewhere in the country. So in the system presumably means different accommodation or different locations around the country. And so I fundamentally disagree with that, because this is focusing on capacity. Now, strictly speaking, the capacity and the need to find accommodation elsewhere is a matter of logistics for the Home Office. It is not a material planning consideration, and certainly not for Epping. The court's role, in my view here, really was to decide firstly whether or not it was an arguable case of a planning breach, and then to go on to consider what we call the American cyanamid rules for granting an injunction, which should usually favour preventing breaches of planning rules and protecting the local amenity of an area which cannot be fixed with money, which is part of the test for an injunction. If you can't fix something with money, then it tends towards granting an injunction to that effect. So, for example, breach of planning laws, if they've breached planning laws and there's a very strong arguable case that they have by change of use, then that lends itself in favour of granting this injunction. But moreover, as I said, I think that finding the alternative accommodation is a logistics issue for the Home Office, not for Epping. And as argued in court, if people can be moved into the hotel quickly overnight, they can be moved out again just as easily. Now, I'd just like to make one important observation about when you read the news, or you listen to the news, or you watch it on TV. You need to be very mindful about which organisation is presenting that news to you, because they may well be biased, because these companies can have a political leaning, left or right, or they might be completely central, many of them are, and even individual stories may be reported differently. Even the BBC has been subject to criticism recently. So I'd like to demonstrate for you, using a story on Tommy Robinson, using a service I use called Ground News, who's a partner to my channel here. Allow me to demonstrate to you how differently these stories can be reported. This, if you recall, was when Tommy Robinson was cleared of any charges in relation to the St Pancras incident, where initially it was alleged that he'd assaulted somebody. And it was all on CCTV, and there's obviously different ways of looking at that and so on. But the news obviously jumped all over that at the time. So now let's look at how this has been reported, now that he will not face charges. So this headline here, Tommy Robinson will not face charges over the alleged assault at the railway station. What Ground News does, it pulls those stories together from different news outlets. It gives you this bias comparison on the right-hand side. It even gives you a factuality score to tell you how accurate the news sources are that you will read and who owns them, if that's of interest to you. But let's have a look at the differences between these headlines. And Ground News's AI feature gives you a bias comparison between the left and the right. So let's take a look at that first of all. Left-leaning coverage characterises Tommy Robinson chiefly as a far-right activist and an agitator, emphasising the political framing that implicitly delegitimises him, whilst right-leaning outlets downplay the severity of the incident, using terms like altercation and employing scare quotes around assault, signalling skepticism towards the accusation. And right-leaning sources go further and highlight Tommy Robinson's prior controversies, viral video footage, and the victim's behaviour, details of which are largely de-emphasised by the left, which serve to suggest a possible provocation. So you can see here the way that the left and the right have twisted this story are very different. And then we can get examples of those headlines down below. Clicking left, you can see some examples of that from the National. Far-right agitator Tommy Robinson avoids charge over alleged assault. And looking at a headline that has been marked as right-leaning from the National Plus, defending myself, Tommy Robinson will not be charged for London knockout. And of course, as a partner to my channel, you get a great discount, which is 40% off, either by scanning the QR code below or going to ground.news/BBB, and that will give you 40% off unlimited access to the world news. So make sure you get both sides of the story, as you can with Tommy Robinson's story here, as reported, and you'll see the difference. And moving on to the second point, Lord Justice Bean goes on to say that an injunction may incentivise other councils to take similar steps as Epping Forest District Council. So again, I fundamentally, with great respect, disagree with this reasoning. Because just because a decision may incentivise, i.e. open floodgates for other councils to follow similar actions, that should not have any bearing on this particular case. And so just to labour the point somewhat here, it has long been the case in England and Wales, in all courts, including the Court of Appeal, to focus on the legal issues in a case, applying the law to the facts, and sometimes only hearing it because it raises a matter of public interest, but still confining its decision to the law on the facts before it, not to engage in speculation or policy concerns or things of that nature. And I'm going to bolster that view in the second half of this video, so please do stick around for that. But coming back to the third reason by Lord Justice Bean as to why he said there was a number of errors in the High Court judge's decision, he says as follows. He says the potential cumulative impact of such ad hoc applications was a material consideration that was not considered by the judge. Now, again, I disagree with this with great respect for a number of reasons. First of all, because I don't think this was an ad hoc application. I think this was Epping Council doing what it felt was the right thing for its constituents, because it was trying to argue that there was a breach of planning rules and therefore wanted this injunction. I don't think this was ad hoc at all, in any other sense that it wasn't just the entire country bringing a generic application for injunction across the country. This was one council. So only in the sense that it was just one council was it ad hoc. I don't think it was ad hoc otherwise at all. And in any event, as I've already mentioned, this speculation on the cumulative impact of any other such ad hoc applications is again hypothetical, it's speculative, speculative and hypothetical on future injunctions, which should not really be a material consideration to this one, unless tied to the specific breach, the specific law, and the points argued in this case. Now, coming back to a point of policy, which I said I would talk about earlier in the video, when the courts are challenged with a legal decision and there are policy considerations behind it. I said I'm going to prove what I thought about it, and I'm going to do so with a ruling from the Supreme Court, and this is going back to the VAT on school fees. But first of all, just a little bit of a vent, because I've seen some articles online which boldly proclaim that there's been no exodus that was reported in the media, that not as many schools and not as many students have been affected as they all predicted. But in fact, I think, with respect, I think those articles that I've read are themselves fundamentally flawed. For example, one of them refers to for the last year, but we haven't had a full year yet. And some of the statistics quoted also do not include school closures between the announcement of the policy and the introduction of the policy, and so those numbers are skewed anyway. One of the articles, which I won't name and shame, but one of the articles is talking about closure of roughly 50 schools, whereas in fact it's closer to 80 schools. And when we look at the number of pupils that the government estimated that would move from private school sector to state school sector in 2024 to 25, they estimated about 3,000 pupils. That is, in fact, now closer to 17-odd thousand pupils that have moved. So many more schools, many more students affected, and at the great detriment to a lot of people. But nonetheless, this was a government policy. And the reason that's important is thus. When we come to the Supreme Court ruling on VAT on school fees, not only did the Supreme Court take the rather unusual step of commenting on government language and sort of taking a bit of a swipe at it, the bit that's highlighted here, the government parties, by contrast, refer throughout to the removing of an exemption or a tax break. And the court says, rather unusually, I emphasize, this was, in our view, more a slogan than a legally significant description. We prefer to speak more neutrally of a tax change. The compatibility of the change with convention rights depends on substance, not on any label attached to it for presentational purposes. In other words, the government's trying to sell you something. Let's stay neutral and look at the facts here. But what's even more alarming and what's more relevant to my video here is starting at the top bit in green, where the court did rule that this change did interfere with those rights, the rights to education. The court ruled as follows. We conclude that the legislation interferes with the individual claimant's rights under A2P1 and Article 14, read with A2P1. In the circumstances of this case, however, the legislature, and this is the important bit here, the legislature has a broad margin of discretion in deciding how to balance the interests of those adversely affected by the policy against the interests of others who may gain from public provision funded by the money it will raise. We've concluded that the challenged legislation falls within that broad margin. Even when considering the claims under Article 14, where the margin's discretion is somewhat less broad, we conclude that the challenged provision falls within it. In other words, the Supreme Court said, whilst this does interfere with the right to education, the legislature has a broad discretion on how to apply and manage the interests of other parties. So if they make the law, that's their policy, we don't interfere with it. So if it's okay for the court to say at Supreme Court level, well, this was the government's policy, so we're not going to interfere with that, then the court should not be looking at policies at all. It should be confined to looking at the law. And in this case here with the Bell Hotel, in my respectful view, it really should be focused on the points of law, not as to prospective or speculative effects across the country. And more fundamentally and behind all the law, I think you'll agree that this ruling and the actions of the Home Office goes generally against the interests of the people in that area and perhaps across the country. That is also something. If they're going to consider these things, they should also take that into consideration. So that may now filter back down to the High Court. The High Court may now take that into consideration and decide, well, that strengthens the argument in Epping's favour, because if we are to take this into consideration, then we should take into consideration the will and the feelings of the people. But again, we'll wait to see what happens in October. But those are just my views. Please do like the video, subscribe to the channel. I'm independent. I depend on you. I'm very grateful to you for sticking with me through the video, and thank you for watching.